hot on the heels of our last session, which was on updates to the Employment Rights Act. What else? We've got Sam today covering reasonable adjustments. So I was having a bit of a think about it this morning and thinking it's quite a topic to cover in 30 minutes, given the width of possible adjustments, the width of possible conditions that we know can qualify as a disability. So it will be a bit of a whistle-stop tour through the topic. But as I say, please do ask any questions as we go. And just before I hand over to Sam, just also a quick point that if anybody has any topics they'd like us to cover in future sessions, so we're going to be doing these around about once a month. If there's any particular topic you'd like us to cover, please do feel free to get in touch. We are happy to cover anything. Okay, on that basis, I will hand over to Sam Butler.
Great, thank you very much, Laura. So I think, as Laura says, this is a huge topic. It's great to see so many people on the call, but I think it probably reflects the fact that this is something that does come up generally quite regularly. And it's an area we obviously see a lot of questions about, and people want to get it right. And that you know there are some grey areas with reasonable adjustments. So what we're going to do today is kind of go back to basics a little bit and cover adjustments under the Equality Act 2010. We're going to look at the legal framework, but we're not going to dwell on the legal text, because it's about what this looks like in practice for you guys. And we'll finish with a case that's very specific, obviously, to those circumstances, but is another timely reminder that these things are fluid, the position can change, and you know, we need to take account of how things are developing in the modern workplace, really. So please do, as Laura said, drop questions in there, and we'll pick them up at the end, but we have set aside some time for questions. It maybe we're not able to answer those questions specifically on the call, but you know, if there's things that you're navigating at the moment and you're thinking this is the perfect timing of this webinar, then please do flag those questions or reach out. Okay, so with that in mind, let's crack on and let's go back to basics, as it were. So the duty to make reasonable adjustments is set out in sections 20 and 21 of the Equality Act 2010. Now, I'm not going to patronise lots of people on this call and talk in too basic format, but it's always useful, I think, to reflect on what the law requires and then think about that in practice. So it is a fundamental and quite sort of cornerstone element of anti-discrimination law, the duty to make reasonable adjustments, because the aim is to effectively make sure that, as far as reasonable, a disabled worker has the same access to everything involved in applying for, doing, and keeping a job as a non-disabled person. And so it's a rare area of law that effectively is what you might call positive discrimination. So that's a term that gets used in the sort of general public, because it's about taking active steps to level the playing field, for want of a better term. And it includes everything from recruitment to day-to-day working arrangements to progression and promotions, and all the way to dismissal. You know, this is the whole employment relationship that this duty arises in. And, you know, many people will see this crop up in job applications because people immediately will have some kind of barrier that stops them accessing roles or accessing application processes in the same way as a non-disabled person. So we do see this right across the employment relationship. So when does the duty arise? Well, you are under a proactive and positive duty as employers to take steps to remove or reduce or prevent these obstacles. The duty arises as soon as you are aware, or you should reasonably be aware, that a worker has a disability. So it may be that somebody goes through their entire working career with you, they never disclose a disability because actually it never impacts on their work, and there is no there's no indication of any of that stuff. Technically speaking, the duty wouldn't have arisen because you've got no idea about that. And similarly, an employee can disclose a disability very early in the relationship, and the duty will arise, but actually there's nothing for you to do. There are no reasonable adjustments because there aren't barriers to them accessing the role and progression, etc. So it is a different situation for each employee, but the general principle is that it arises as soon as you're aware or ought reasonably to be aware that a worker has a disability. And that second part, that kind of being you ought reasonably to be aware, is an important one. Because particularly in large organizations as well, if an employee, for example, tells their manager they have a disability, as the employer, you will almost certainly be deemed to know about that disability, even if the information isn't passed on to HR, or even if or occupational health, for example. And realistically, you're not going to be able to say later down the line, well, they told their manager, but we didn't know about it in HR, or they told their manager, but actually we didn't know that we needed to do anything about it. Okay. And similarly, there is a responsibility for you to be watching for kind of red flags if an employee or a worker or an applicant, I'll use those terms slightly interchangeably, but we're all aware that it does apply to everybody in those circumstances. If they start to demonstrate signs that might indicate a disability, you need to be kind of thinking about this duty as well. So we'll spend a moment on what counts as a disability, because again, we see this a lot in practice where people will jump straight to reasonable adjustments because someone declares a disability, but actually we don't dissect whether or not it is a disability. And of course, conceding, for want of a better term, an individual having a disability may then impact you later down the line if there are tribunal claims. But the core principle is that the Equality Act definition, it's contained in Section 6, is not diagnostic, it's functional. So it's about the impact of that condition on an individual. And the question really is whether or not that impact, physical or mental impairment, has a substantial and long-term adverse effect on an ability to carry out normal day-to-day activities. Substantial, we know in that context, means more than minor or trivial, and long-term we also know means it's lasted or is expected to last more than 12 months, or at least 12 months. Now, a few conditions are automatically classed as a disability on diagnosis, so cancer, HIV, MS. But particularly conditions, neurodivergent conditions that we're seeing more and more of, things like ADHD, dyslexia, dyspraxia, autism, there's no automatic status, and it does come down to that functional impact. But crucially, you don't need a formal diagnosis for it. So there is a bit of a balancing act to strike as to where you determine whether someone would qualify for protections under the Equality Act. And so, like I said, even if someone's presenting at work with real difficulties that might raise some red flags for you, that might be the thing that makes you think, have we got somebody here in front of us who may qualify for that disability protection? So once we've concluded and we're comfortable that there is a disability, what are the triggers? Well, the duty's triggered in three ways. One, what we call a PCP, which many of you will know stands for a provision, a criterion, or a practice undertaken by the employer. It might be a physical feature. Secondly, it might be a physical feature of the building or the premises. And thirdly, it might be around auxiliary aids, which are obviously very, very specific. But PCPs are the one that we see most. They're very, very broad. They include policies, they include performance standards, they include requirements to work a certain pattern or shift. A PIP, a performance improvement plan, is in of itself a PCP. A requirement to process information in a certain way is a PIP. Both are particularly relevant for neurodiversity. So the core question of, well, what is reasonable? I'm afraid to say this is your classic lawyer's answer here, which is it depends. There is no checklist that you can go down and say this is reasonable. And what is reasonable in one situation may differ from another. So, for instance, where somebody's already employed with you, they've been there 20 years and they face losing their job without an adjustment, that is different to a job applicant who's attending an interview. The stakes are higher, and tribunals will take that kind of thing into account. So a larger employer, generally speaking, is more likely to have to make certain adjustments, such as redeployment or flexible working, which may simply be easier for them because they've got more staff. So again, that kind of thing is taken into account. So when we're looking at reasonableness, we're weighing into, we're kind of balancing up and weighing whether the adjustment actually removes the barrier, so the effectiveness of that adjustment. What are the practicalities of it? What are the costs of it? Proportionate to your organization's size and resources. And many adjustments, they're not particularly expensive. and you are not required to do more than what is reasonable. But it's really the ones that kind of straddle into that grey area of what's reasonable, what's not, that cause the disputes down the line. And there are disputes. This is a very common claim that gets brought. It often gets brought with other claims, so it's often chucked in with a disability discrimination or unfair dismissal claim, often as a way to kind of ramp up compensation as well, actually. Because if a disabled worker can show there were barriers that you should have identified, and there were adjustments that you could have made and you didn't, that leads to a claim in the employment tribunal, and you might be ordered to pay compensation as well as actually implementing the adjustments. So if someone's going to stay with you, it is a claim where you could have a existing employee, they bring the claim, you're required to make the adjustments and pay compensation on top. Okay, so we'll just pause briefly on occupational health, because this is something that people they sometimes jump straight to it, they sometimes leave it a little bit too late, it's not quite sure where it is. But occupational health is both a tool and a source of risk, basically. So it is we do see it being misused, often not deliberately, of course, but it is a tool if it's used really well. So occupational health can help you to make good decisions about adjustments ultimately. Okay, so when an employee does disclose a disability to you, or you've got those red flags, a timely referral to occupational health might be just the ticket. Okay, because it can take away the tension, but sometimes between an employee and an employer, but also it can give you real specialist evidence and advice. And so a good OH report will usually help you understand the functional impact of any condition, how long it's likely to last, and what adjustments might help. But importantly, the OH report is an input to your decision. Okay, it's not the decision itself. And tribunals regularly see cases, and we often see it, where an employer's either said, well, we just did exactly what we were told in the OH report, kind of blindly followed it, or they say, well, the OH report said no adjustments, so we didn't make any adjustments, kind of relying on it in too strong a term. And neither of those approaches are particularly safe, I'm afraid to say. So the position of knowledge, again, is important here, because obviously once you're providing information to an occupational health advisor, they are your agent as well. And so if an employee is disclosing information to them, there is often, or there may be a dispute as to whether or not the OH report discloses all that information back to you as the employer, maybe a conflict between the employee and the employer and what they want to be shared. We can work that kind of tension out, but ultimately the OH assessor is your agent, and it's usually you're not able to then claim again later down the line, well, we didn't know about any disability because they only told the occupational advisor, didn't tell us, as it were. So if your occupational health advisor has identified a condition that amounts to a disability, or identifies symptoms that may amount to a disability, that knowledge is your knowledge effectively, and the clock starts running from that point. So just reflecting on using OH well, particularly for neurodivergent people, it's all about how you frame your referrals. Okay, so not just saying, is this person fit for work? Asking specific questions about barriers, what barriers can be lifted, how does this individual see their condition impacting them at work, what adjustments might remove those barriers, is it likely to be a disability, how long is it likely to last? These are really important questions, and framing that correctly will help get you the information that you need. And it's always advisable to have the employee involved in that process. And sometimes we see a situation where an employer kind of forces OH on an employee because they just want to get it sorted. But ultimately, an employee who feels part of that process is going to be more willing to give useful information to the OH assessor to be able to then give you useful information to make adjustments as well. And working together between OH, HR, and the employee, that's going to make better decisions, both best practice and a better application of the law. Okay, so just want to talk about EHRC guidance, because this is really useful and practical stuff, and that's what we know you're all here for effectively. So very briefly, The EHRC has some guidance. It's called Employing People with Workplace Adjustments. It's a key resource and it's free, crucially, not to do us out of any work, but it is free and it's useful for you guys. When something arises and you just want a quick sense check, you can use this guidance as well. And there are 3 key pages. We'll send out this information, of course, afterwards. You don't need to make notes or anything, but there's 3 pages that are worth bookmarking when you have a look at that guidance. Examples of reasonable adjustments. What do we mean by reasonable? And paying for reasonable adjustments, because this is a question we get asked. And on that point, to be clear, it's an employer's obligation to fund adjustments. Okay, and that's why cost and resource is a relevant factor. So you can't ask an employee to be paying for their adjustments. There is the government access to work scheme, which some of you will have had success or not with, I'm sure. But it's not a substitute, and you can get a grant for things, but that's not a substitute for your obligation to make those adjustments. Okay, it supplements it doesn't replace it. So it can be particularly useful for access to work. Can be particularly useful for things like neurodivergency, where there might be specialist software or coaching or assessment costs that are involved, and so it's worth signposting employees to that service as well. So let's have a look at some practical examples of what reasonable adjustments actually are in practice. And I've selected a handful. There's obviously lots more out there. There's no, this is how long is a piece of string, really. I've selected some key examples that are probably going to be the most common coming across your desk. So the first one, flexible working and hours. And this one's even more relevant at the moment because of the new regulations around flexible working requests. So allowing a disabled person to work flexibly to overcome fatigue or to attend meetings and appointments. And that includes permitting part-time work or completely different hours to avoid rush hour traffic, even because that might be kind of particularly damaging for neurodiverse people. Those all can be reasonable adjustments. A phased return after a period of sickness, a gradual build-up of hours, again, that might also be appropriate. And one question that often comes up here is, how do we balance this against a flexible working request? Reasonable adjustment request, flexible working request. How do we do this? No requirement to run those 2 processes separately. And indeed, it might actually be better to run them together as long as there's really clear documentation about your rationale for both frameworks, because the 2 frameworks are different and unhelpfully, and they don't always align. So you could find yourself in a position where you've complied with one and not the other. And so that's why that documentation of your thought process is really important. So the statutory grounds, for example, for refusing a flexible working request, they don't map onto the reasonable adjustments test. So we need to be keeping both, even though we might combine the processes, we need to be keeping the processes kind of running in parallel so that you can properly explain how you've come to any decisions you have. So breaks and pay, these are also really common. So a disabled worker, these aren't rocket science. They might need more frequent breaks. They might need short breaks instead of one long break. But again, crucially, you can't dock their pay for increased breaks. Granting breaks but docking pay isn't maybe in and of itself a failure to make an adjustment, and sometimes that's not often appreciated until it's too late. Equipment and training, this is kind of, again, very, very common. You might provide different training for people with different conditions. So particular training, particularly with neurodiversity, might need longer training sessions. They might need a different format for delivery of training. They might need to have someone sit down with them and explain things in a slightly different way. Of course, individuals with physical impairments may need different equipment, very, very common, things like chairs with back support, or different style monitors, or, I've got a wrist support for my mouse mat, for my mouse, and those kind of small but quite impactful things often are very common. You might also be thinking and seeing more and more requests for things like instructions to be written down, somebody not being able to handle verbal instruction, or not being able to handle emails instructions over email. So again, these are more common. We're seeing these particularly with those suffering from ADHD and autism and neurodiverse conditions, the requirement to think about the way in which you're delivering instructions or giving feedback on work as well. Absence management, this is where you might decide that you're going to relax absence triggers for formal processes is really common, particularly where absences relate to disability. So this is where you'd need to be thinking about things like return to work, really getting on top of understanding why absences have occurred and how they might be avoided. But ultimately, if someone's got 17 appointments in the next 12 months for a cancer diagnosis, it's going to be really, really harsh if your absence management processes are triggered by 15 absences. So that's a very, very common adjustment to make as well. We're seeing more and more of this actually as well, advocacy and support in formal processes. So, individuals with disabilities, they might, we might allow them to bring more than a friend or more than a work colleague or a union rep to meetings. You might allow them to bring a friend or a partner who might understand their condition in a different way, or you might say you're going to give more time again to process information as part of these processes that you would to a non-disabled employee. And it's interesting because often people will say, well, hold on a minute, it's positive discrimination. It's, we're actively, that's exactly what you're doing. And you should feel comfortable doing that because it's about alleviating disadvantage. So we need to be, thinking about who's running these processes as well. Are they aware of any disabilities? Asking employees outright at the start of processes, are there any adjustments that we can make to make this process more understandable or simple for you? So we're just thinking about implementation for a second. It's unlikely to be a valid defence in a tribunal claim to argue that an adjustment was unreasonable because your staff were obstructive or unhelpful when you tried to implement it. Okay, so you are responsible as an organisation for making adjustments actually happen and not just agreeing to them on paper, which is really important. So I know everyone always gets bored by the case updates, okay? So I'm not going to give you lots of detail on this, but it's important for us to reflect on the fact, and we see this all the time in employment law. Employment law reflects society and it reflects how things change in society. We might not always agree with the speed at which that changes, but it does, and courts and tribunals are finding more and more and more and more cases that are challenging understandings and perceptions around things like mental health and disability across the board. So, this is a case that we've just identified. There are hundreds of cases that we could identify, but this is a useful one from 2024. It was the appeal tribunal, so it is binding, and it looked at an individual who'd been at at Rentokil for a long time. He had a physical job. He was out on patrol, as it were, and basically he had MS. So he's automatically qualified for disability status, and it turned out he basically couldn't do his job anymore. And he said, well, I'd like to stay within the business. There's an admin role. Why don't I just do that instead of my physical role? And basically, after a long deliberation, the company said, well, the problem is you don't have the skills to do the admin role. You've done the other one for 20 years. You don't have the skills to do it. So we can't redeploy you. And basically, the employment tribunal and the appeal tribunal concluded he was ultimately dismissed from his role for capability. And the appeal tribunal basically said, in those circumstances, redeployment is absolutely a reasonable adjustment, even if that means that you have to go to the expense of training somebody up in a role that they don't have the skills to do in that moment. And that's why I mentioned earlier, that the difference between somebody who's been in a role for 20 years and their career's at stake here versus a job applicant. You might have to take additional steps that are going to cost you more money and take more time. And redeployment is a particularly useful one when we're talking about long-term absences. So I'm going to pause there because we're at 12:57. These are your key takeaways. This is a massive area, so I feel relatively happy actually that we've covered quite a lot of ground in not a huge amount of time. But those are your key takeaways on the screen. We will follow up with the slides and also with recording and that EHRC guidance. But if there are any questions, I'm happy to deal with them. I can't see whether things have popped up in the chat or not. So I'll pause there. Oh, you're muted, Laura.
Sorry, I was speaking and on mute. No, thanks very much, Sam. I was just saying that there aren't any questions in the chat. If anyone has any follow-up questions, obviously, please don't hesitate to get in touch. It is a lot to cover in a short space of time, but really, really helpful, I think. I mean, I was making notes through that myself. The one thing that always strikes me with reasonable adjustments is that you could make 9 reasonable adjustments, and if the tribunal finds that there was a 10th that you didn't make that you should have made, you will lose your claim. So it isn't about, oh, I made some reasonable adjustments. It's about making all reasonable adjustments. And as you say, it's really hard to assess what's reasonable because it's proportionate to the size and resource of the company. I did once have a client who, I mean, huge employer, one of the biggest in the country actually, and their finding was that it would have been reasonable to put in place a wheelchair lift in the entrance to one of their stores. So huge expense. I mean, I think it was £50,000 or something to do it. So when you think about what's reasonable, it really does come down to the size and resource of the business. So anyway, just wanted to say thanks again for that, Sam. I thought that was really helpful. Hopefully everyone else did. We will follow up, as said, on follow-up or any time before that. Please don't hesitate to reach out with any questions. I know that you will all be grappling with reasonable adjustments in one way or another at some point over the next year or so. So thanks again, everyone, for joining us. Hopefully you can join us for our next session next month.